pointing you to one of these institutions, you might want to think again whether that's a good idea. Russian law is like many laws. It has a few unusual features. It doesn't allow corporate disputes to be arbitrated. So in theory, if you're working through a vehicle in the Russian Federation, you may find that you're subject to the compulsory jurisdiction of the Russian courts and the Russian law. There are lots of ways of getting around that. And it won't sound like an unusual problem to you. You will have probably come across rules like this in countries all over the world. It's a way that national legal systems try to maintain a level of control over the internationalisation of legal contracts. Because what people do now is that they will, you might enter a joint venture for your upstream project with a company in Russia or a company in any corner of the world, but you'll probably say that the shareholders' agreements might be subject to English law and disputes to be arbitrated in Geneva. So what you're trying to do is to lift all disputes out of the context of the local legal system, and you find rules like this trying to design to stop you. Some of it is just, how can I put this, domestic legal parochialism, thinking what's wrong with our laws, perfectly good. Some of it's more overt attempts at state control over transactions. Some of it's just damn confusing, because law doesn't always develop in rational ways. And in the few cases where people have tried to write down the law from scratch without adding bits on to make everything more and more complicated, Napoleon tried it. The law got added on, made more and more complicated anyway. So that's why you'll find a lot of very strange legal rules in a lot of jurisdictions. And you have to be alert to them, because you almost certainly don't want to be bound by them, and you've got to find ways of getting out of them. Recognition in arbitration is done under the New York Convention 1958. Every CIS country, I think, except Turkmenistan, has signed up to this. The idea here is that an arbitration award should be automatically enforceable in virtually anywhere in the world. The reality is never, of course, quite that simple, but let's say that it's much easier to enforce an arbitration award in Switzerland than it is in Azerbaijan, for example. There are some jurisdictions in the world where it is notorious that it is virtually impossible to enforce arbitration awards. The Gulf is the main problematic part of the world. But these days, problems of enforcement and cross-border pursuits of assets, say when you're dealing with gross fraudsters who are determined to move assets quicker than you can freeze them. And there aren't so many of those cases, but they do happen. These days, cross-border enforcement is less of a problem because everybody, even people stuck in sanctioned countries, have their assets in such complicated networks that you can more or less always find some jurisdiction somewhere where you can enforce. So mostly, these days, arbitration awards and international court judgments are self-enforcing, because the agony you can cause to an opponent who has assets in lots of different places, if they don't comply, is sufficient that generally they will comply. And then negotiations take place in the shadow of the law. In fact, then, once you've done with the enforcement phase, you can take out the judicial phase, because you can just predict what the judge will do and settle on that basis anyway. So such is the idea. I'm going to quickly mention sanctions, because this colours my future life. Sanctions, of course, we're lawyers, we know how to deal with sanctions, because what are sanctions? It's a legislation, and we know how to get around them, that's what we're paid to do. Sanctions colour what lawyers do, but virtually never make it impossible. The people who really make sanctions a nightmare are banks. Most sanctions are fairly easy to get around with a clever lawyer. The problem is that the banks won't have it. And it's not the text of the sanctions. Most sanctions, by the way, are drafted by politicians, not by lawyers. They're political documents. They're virtually impossible to understand. But they create a chilling effect on banks, and banks say, we're not going there. Hence Iran. Hence, the main effect in sanctions with Russia now is on the banks. It's the lending restrictions. That's how sanctions work. They block up banks. They don't block up lawyers, they just help us charge you a bit more in money. But it's the banks that make them work. The sanctions we know are in place are those related to investments in work in Crimea, certain government-backed energy in key sectors, and Sberbank, VTB and Gazprom Bank. That's where the sanctions have bitten in Russia, and in energy, and in military. Military is not so effective, but it's banking. What Russian companies now can't get is loans. If you can provide them with money and financing, you'll be popular. To some extent, we've had a few disputes arise out of people saying, well, I can't do this deal anymore because sanctions have stopped me. Those sorts of arguments sometimes work, but often don't. I'll just point that out to you. Mostly, sanctions themselves are not tailored in such restrictive ways that you simply can't get out of the deal. You can, and you can probably keep doing the deal. It's just going to become more difficult for you to do so. I give people lots of advice. They say, Matthew, we need a sanctions clause for our contracts. You know? I tell them, okay, we'll draft you one, but the problems with sanctions clauses is they almost always go to litigation if people try to withdraw from a contract after sanctions come into force, and then you could never draft a sanctions clause so effective and so comprehensive that it actually captured what actually in the end happened. Because what happens is that sanctions get drafted up by politicians in smoke-filled rooms at the last minute and imposed, and you think you know what they're going to do, and actually they end up doing something different. Oh, your sanctions clause didn't capture it. Unless you want the sanctions clause longer than the contract in itself, then it's going to be virtually impossible. With those few concluding remarks, because I know we're all already a little bit late, and listening to law for more than about half an hour, and unless you're a judge, tends to fray the finest of men's patience. I'm going to leave it there, and if any of you have any questions or comments about specifics and details, I'll be delighted to answer. Thank you very much for listening to me.
Thank you, Matthew. Any questions for Matthew? Ruben. Unlike you to ask a question, Ruben. We're going to keep this one short and sweet, aren't you?
That's right. I promise. Matthew, there are big companies in Russia who are still doing, although they are on your list, they do roadshow, they place notes, and Western investors or financiers give money to them. How it is sort of related to sanctions, for example, Gazprom, I heard, raised some money, although Gazprom is on the list. So my question is, do big commodity companies have access to Western finance, even if they are in the list?
Those are two slightly different questions, but I'm going to try to blend them together into one answer. The sanctions restrictions on those three Russian banks essentially prevent Western banks from engaging in long-term lending into them. So, I mean, the way Russian banks have traditionally worked is that they've been financed by European banks. And then in 1998 it all fell apart and everybody started arbitrating and litigating, and then we went through that again 10 years later, and off we go. But there's no reason why, again, I say this is a lawyer's point. You can invest in Russia if you've got cash. You just have to structure it carefully. I mean, those banks have suffered because the restriction, remember, is on a Western bank, a European bank, from making a long-term lending commitment. And many of those banks have run away. But if you want to do business in Russia, you can find countless other ways to structure your investment that doesn't fall foul of those provisions.
So corporations have access?
Yes, fully. There's nothing stopping anybody doing any business with Russian companies. It's a lending restriction. And everybody's going about their business. I mean, Russia's far too big a market just to be cut out. I mean, the sanctions have hurt, but they've hurt in unusual ways. They've hurt like the depreciation value of the ruble. because they've undermined a lot of confidence in the domestic banking system, as I understand it. It's things like this that have really caused Russia some economic damage, rather than the sanctions having the de facto effect of excluding large Western corporations from the Russian market. The Russian energy market is simply too important for large companies to be excluded or to run away from it.
Sir.
Thank you. Good morning. My name is Emeka Akabogo. I'm a lawyer from Nigeria. The tendency is for English interests to glorify the English jurisdiction.
Of course. How do you think I'd make any money otherwise?
This is not allowed. Let's not do this.
But wouldn't you think that for the purposes of a choice of law jurisdiction, it would be more important to base that on the significant domicile of the transaction? Given that, if, for instance, the transaction is going to be largely undertaken, say, in Nigeria, an enforcement of any dispute-related judgments will have to be done in Nigeria. Domiciling the jurisdiction in England may ultimately be otious, really.
I'm a believer in freedom of choice. There are some legal systems that are better, and there are some legal systems that are worse. And I don't have to sit here and preach to which the market can answer, given freedom of choice. People can write into their contracts whatever law they think is going to be the best and most effective in enforcing the deal they've done. Having said all of that, parties have different bargaining positions. I have seen many domestic laws written into long-term production sharing contracts over the insistence of multinational oil companies. That has happened because the country in question, the government has simply said, if you want that production sharing agreement, you're going to have our law in it, whether you like it or not. This sometimes produces some curious results, by the way. I once had a case where we had to work out what the law of the Democratic Republic of Congo was. And that was quite difficult, because the country didn't have a commercial law, because it had been involved in a civil war for many years, and its courts hadn't been operating. So sometimes, Nigeria is certainly not like that. Nigeria has a sophisticated legal system, but the problem you're always going to face in an international transaction is that people are going to say, we don't want hometown justice. We don't want the local courts because we think the perception is they might be biased against us, and we don't want the local law because you, our counterpart, has more familiarity with that than we do, so we choose a neutral one. That's how the rise of these different sorts of commercial law, choices of law, took place.
I just want to follow on, because I rudely stole the microphone from you. Isn't, though, Matthew, the reality, I think what Emeka was really, if I understood it correctly, was really pointing at this idea of lex situs, law in the place at which the deal is being done. And I have a suspicion that if you have a dispute, for example, let's leave Nigeria for a second, shall we, Emeka? But let's go to Dubai, for example. You, in the end, if you want to take control of your collateral, if you want to take, you've got a customer that's in default, you're a lender, for example, and you want to, get physical possession of goods of the collateral, you actually have to submit yourself to Dubai law to get your hands on those goods. English law is of no value or use to you in Dubai. So I think, am I right? Or maybe the distinction is, when we talk about English law, Emeka, I think we're saying this is the high seas stuff. I don't think this is trying to transpose English law into the domestic Nigerian space. Am I right about that?
No.
This is very interesting. We'll wait to see what the trade financiers say in the trade finance panel, Because this goes against everything we've been told, Ivan, for a decade, I think. There we go. Sorry.
The question is this. Is one jurisdiction going to respect the orders and awards of another jurisdiction that the parties have chosen? Now, if the answer is no, we won't respect them, you must come to our court system, yeah, then that country is going to find itself having economic problems because there is a disincentive, yeah, for investors or commercial people to participate in economies that don't permit choices of law that people want to engage in as free market agents. And the net result, of course, is that what you have to do is to build in an additional transaction cost into the risks of the local legal system. I'll say a few words about Dubai because it's interesting. The Emirati federal court system is regarded by some people as moderately unsatisfactory. So much so that there was commercial and political pressure to create another legal system in the United Arab Emirates called the Dubai International Financial Centre, full of English lawyers and judges. And that is now treated, for the purposes of Emirati federal law, as a separate emirate. So you walk in that building and it has all its own laws, judges and courts. And that was created as a result of political pressure because people found doing things like asset forfeiture or seizure in the conventional Emirati courts unsatisfactory. And now the Emirati authorities are obliged to enforce DIFC judgments just as much as they are the judgments of the courts of Dubai or of Abu Dhabi. And by the way, a little trick. Although it's completely hopeless enforcing arbitration awards generally in the United Arab Emirates, let me tell you how to do it. Here's a free takeaway. I won't charge you for this. You take your foreign arbitration award to the Dubai International Financial Centre Court, you get them to register it automatically, and then they'll enforce it for you. Perfect.
Thank you very much, Matthew. Thank you very much. It's all good stuff. You know, Matthew's a Yorkshireman, that's why he's so direct and tells you what he really thinks, which is great. Thank you very much, Matthew. So now it is the Trade Finance panel. Nicolette, you're coming up here. Nicolette has very kindly still moderating this panel, having in fact been in hospital